Hi, I'm attorney Rilus Law, and I'm here with my friend Marvin from Night Owl Realty. Our first video, if you missed it, you can go back. We talked about probate and what is a will, what's a last will and testament. Now, this video, I want to tell you a little bit more about how Marvin and I met and how to work with a probate attorney like myself, and really just what to do after someone passes away, how you evaluate that estate and situation. So welcome, Marvin. Thanks for joining us.
Thank you, Rilus, for having me.
I'll share my side how we met. I get stuff, every week, as you can imagine, from realtors and different people, all wanting me to use their services or to request their services for my clients when they need to sell a house or do those things. I also get hit up in a lot of places. It's hard to keep up with. I get messages on Instagram and Facebook. The worst one I get, it's kind of funny, or two bad ones. This is what not to do. They say, "Hey, can you call me if you have a second?"
Right.
It's like, no. Or another one of my favorites is, "Can I ask you a question?" And it's like, well, you just did, and you blew it by not asking your question. like if you're in my DMs, like, ask your question. And also kind of another version of this too, people will see me on YouTube and other places, and they'll call my law firm, they'll want to talk to me, but they won't tell my team what's going on.
Right.
Like, no, I just want to talk to Rilus.
Right. They're trying to get to you specifically and directly.
Yeah, it's like, they're there to help me. They are me. I pay them to ask you those questions. I am paying them to help you.
Right. And they are an extension of you.
But you got to let them help you. And I kind of got into it. I was like, dudes, like, guys, come on. Like, if you would have passed that message on, like, I could have helped you sooner, but I had another client waiting for me, in the office. And I heard this going on on the phones. So I was just like, what do they want? It's like, if you would have delivered that message to my team, they could have helped you sooner.
Right. Absolutely.
That's how not to approach attorneys. Now, how to approach attorneys, what you did is, you brought me a prospective client, right?
Absolutely. Yes.
So the way you came on my radar, was it you that called my law firm first, or did you tell the people to call me?
No, I reached out to your law firm first. That way I could introduce them to you. That way you could reach back out to them.
And how was your experience?
My experience was good.
But what'd you say when you called the law firm?
Hey, I said, hey, I actually, initially, I did ask to speak with you. And then they said, hey, I'm going to put you on with the probate specialist that we have here. I provided her the information, and then she reached out to the clients that I referred to you. And then you had a conversation with them. And then you and I followed up later and had a different conversation.
Let's pause. Let's break that down. So what you did, though, the reason you got further in my phone systems is because you had a client. So the first person, I have like an answering service that's very basic, so she'll transfer anything related to, if someone passed away, she'll transfer it to our other legal secretaries or paralegals. So it sounds like you got past that first level, but it's because you had a current condition, like you had a current situation.
Absolutely.
Right. You weren't calling and say, hey, I'm an investor, I want to talk to Rilus to see.
Right. Or, hey, I'm an attorney, I'm a broker, and hey, do you have any probate that you want to give me or nothing like that? I came providing value first.
Right. So you came in through the front door of my business with exactly what we're looking for. So that you're always going to get in that way when you bring a prospective client that I'm looking for. So that's how you came on my radar. And I will say you got good marks from the beginning.
Well, thank you.
My team's watching, right? They give me the report.
Right.
It's funny. Some people are really rude to my staff. And I know that. I get those notes ahead of time.
Right.
People are usually nice to me, but it's kind of surprising, who's mean to my team. But no, you got good marks because really you knew the situation, and that's what we're going to talk about a little bit more. I'm gonna hopefully teach others what to do. Whether you're looking at your own family situation or how to approach any deal, but you seem to kind of know the lay of the land. And again, this is just the message I'm hearing from my team, because we get a lot of calls from, sometimes it's new investors. They're like, hey, can you help me with probate? And they talk to my paralegal and they're like, oh, my neighbor died. I want to buy their house. It's like, have you talked to him? Well,
Right.
no. Well, what do I do? It's like, you called us way too soon on that point.
All right. I mean, you got to
So
have the conversation with the person first, that way you know what you're up against. And if you even have a chance of even possibly even maybe getting that property or having that conversation. So I would agree with you. Talk to the person first before they even reach out to you.
I think that you deduce that there was a property and that there's also a trust, right? Were you
Yes.
aware of that?
There was also a trust. They were named in the trust, but there were some other issues. And that's why I referred them to you, because I knew that you would be able to handle them and help them with that situation.
So you got good marks from my team, from my probate paralegal, and they were able to schedule a consultation with those people.
Yes.
Who was able to meet. And then from there, that's how we met.
Absolutely.
So now I hear Marvin. It's like, yeah, I like Marvin.
Well, that's good.
I know that he's trying to bring me business
Absolutely.
and the exact business that I'm looking for. And you've gotten good marks from my team. So
Well, I'm glad to hear that. And I appreciate you, reaching back out to me so that we could have conversation and more dialogue.
yeah, so let me share my screen here and let's teach people how they can evaluate an estate. So after someone dies, this is the order that I go through.
Okay.
So I start with the money, right? The assets. What are we talking about?
Right.
And a lot of times it's real estate that might trigger it. If you have IRAs and retirement accounts and life insurance, they're usually controlled by the beneficiary designations.
Okay.
So things like that, you want to look to see who they're payable to. Now, bank accounts, they could be in the name of a trust or a person individually. And same thing with real estate. And then two, the next I have is define the players. So decedent, what's the decedent? It's a fancy word for what?
A person who passed away. A person who
Yeah.
is no longer here on earth, let's just say.
Yeah. Dead guy. I guess that's a nice way of so decedent, who are we talking about?
Right.
What's a fiduciary?
A fiduciary is the person that is in charge of handling their state or their affairs to make sure that it's done correctly. So
Right.
that's their role and responsibility.
Right. And then beneficiary, what are those? What's
That's
that?
the person that's going to receive whatever the assets are that are left once they're divided up, or bills and all these other types of things that are paid.
Right. So this is how my brain works. This is what I start to do. All right, first, what are we dealing with? All right, who are the players? Right? Is it one person that passed away? Is there a wife that I'm dealing with, or is it children, or is there multiple children that are beneficiaries? And then what controls the assets? So IRAs and life insurance, like I said earlier, they could have a beneficiary listed. If there's a beneficiary listed, then that's controlling. The house, if it's titled in the name of the deceased person, it's controlled, or it could be in the name of the deceased person or a trust.
Okay.
Same with the bank account. So bank accounts could also have beneficiaries too. So it's possible the bank can name a person as a beneficiary, or maybe even a trust as a beneficiary. All right. So if assets are in the name of the deceased, we know they're controlled by their last will and testament, right? If you
Correct.
watched our first video, you now know that.
Absolutely.
And if there's no will, we go to the intestate succession, look up the laws of intestacy in that state to see who has priority to serve. If there's a trust that owns a bank account, you look to see what the trust says. The trust should tell you who the trustee is. Where it gets fun is if there's no trustees listed, or the scenario, the people you recommended to me, that it was like a long lost person that was listed to serve as a trustee. So, and then who are the beneficiaries? The trust is going to say that. So fiduciary, so the person in charge, we call it the fiduciary is because in the trust, it's called the trustee. The last will and testament, it's called the personal representative. So fiduciary is kind of the general term. So if you're listed as a fiduciary, it's your job to safeguard everything, to get the formal authority as well. So in my example here, it's like to put on the hat is kind of how I view, right? You may be named. So in the last will and testament, if you're named as a personal representative, the way you get the authority is through a probate.
Right.
And then you got to report to the federal and state governments. If you're listed in the trustee, there still is some paperwork to do to formally accept that position as a trustee and to prove that you've accepted that position. Then you follow the trust, right? So then once you get appointed, you follow what those documents say or what the laws of intestacy say.
Right.
If it's unclear, right? Sometimes it might be a bad trust. Maybe it contradicts itself. I see that happen sometimes.
Okay.
Hopefully not my trust, but sometimes what happens is they might lose part of it. They might lose one of the amendments that name someone, or there's all sorts of fun things that happen when you got to start practicing law, right? If we have the rules here and they're not good enough, that's when I say practicing law. So I'm a little biased as an attorney, but I always recommend that you hire legal counsel. So if you're named in the trust or the will, what are your thoughts on that? So again, I'm biased as an attorney, but as an attorney, I just see you have all the liability. If anything goes bad and you're the fiduciary, the beneficiaries can say, you should have done this.
Right.
And here's what I hear a lot. People, they say, I tried my best.
Sometimes your best is just not good enough, and that's part of the problem.
You have to tell that to the judge. You tried your best. In hindsight, it's clear to see what you did, lost money. So therefore, you're probably gonna be liable for that.
Right. But I would agree with you. I would hire someone to handle that process for you, especially because, like I said, there's so many moving parts and so many things that the lay person don't know, that attorneys like yourself do know. So it would make the process way more smoother if they hire someone to handle that for them. So I definitely agree with you.
Here's the other part of my pitch too, is I help the personal representative or the fiduciary, I help them get paid. A lot of times I say, how much do you want to charge for this? And they go, what do you mean? And I say, well, you have a lot of liability if you take this on. So you are entitled to reasonable compensation for taking this on.
And I think a lot of people don't know about the personal representative compensation piece of it.
Yeah. Here's another important detail too. Let me go back here. Let me go back up. Sometimes it's a challenge just to figure out what the assets are, right? Sometimes we don't know.
Right.
With real estate, it's easy to look up, especially in Arizona. You can find the deed and see who the owner is. But with a bank account, that's not exactly obvious, right? You don't know who the owner is. And the bank can't tell you anything unless you are that owner, or you show that you have the authority of the estate.
Right.
For doing a probate. Sometimes I'm meeting with these people and they go, I don't know what's out there. I think there's something here at Wells Fargo, but they won't talk to me.
So what would you say would be the best way in that scenario for someone to get around that, or how to deal with that to find and locate those assets?
Let's talk briefly about probate alternatives.
Okay.
So in Arizona, you can do what's called a personal property affidavit if what you're collecting is worth less than $75,000. And that's the only thing that's not in trust or that doesn't have a beneficiary. So if that's the only thing in the name of the person's estate, Arizona allows you to do that small estate affidavit.
Correct.
So what I recommend in that situation is you go to the bank and see if they'll tell you, say, hey, I'm meeting with an attorney. I'm trying to figure out if I need a probate or if it's less than 75,000. Can you at least tell me that?
Right.
And usually they will. So if it's, a lot of times they're pretty good at this, actually, if it's below that amount, or not always, the banks, a lot of times they're horrible, I should say. They're not always helpful, but you might get a good banker in there, right? Once you work your way and get a good banker, they might even give you one of those small estate affidavits. They say, here, if you fill this out, then we can help you get that account.
Right. And so for someone who find themselves in that position, should they have the death certificate with them when they go to the bank? Is that
As much as they have, the better.
right?
Now, sometimes they don't have it yet, but if they have a death certificate, great. Take that. Take whatever documents you have, because a lot of times it's the same person named in the will and also named in the trust to serve.
Okay.
So what I tell them is, just assume that they put it in the trust or that it's in there, and just go as far as you can until they stop talking to you.
Right.
Right. Because if it's not in the trust, they're not going to be able to give you that information. If it's in their name and they passed away, what you want to figure out then is also if there's beneficiaries. I've called a lot of these banks, and what I do is, again, you try to get as far as you can, see how much information they give you, and then once they stop, just be like, okay, well, can you tell me if there's a beneficiary listed?
Right.
And then it's like, okay, even if it's not, me or my client, will you reach out and contact those beneficiaries?
Right.
And sometimes what we have to do is, we think it's this person and that person who are passed away. Can you tell me if it is those people?
Right.
And then once you start giving information, the big, well, it is that person. And if we know that person's passed away, that's listed as a beneficiary, that has the same effect as no beneficiary listed.
Okay.
So no beneficiary listed means controlled by a state, the dead person's name individually.
Right. And then at that point, when it goes through probate, is this the piece where the judge will name a personal representative if there's no beneficiaries named, let's say, in the will or in the trust?
Yeah. So let's say there's an IRA with no beneficiaries listed.
Right.
So then it's part of the estate.
Okay.
Which is controlled by the will if there is one, or just the default order of who the beneficiaries are. Now, but let's go back to the scenario. What I wanted to get at earlier is if we don't know what assets are in the estate. So
Right.
if you came to me and said, okay, Rilus, my parents passed away. I think they have something at Wells Fargo, but what if I find out they have a bunch of debt? You're telling me you're not going to do probate for free, that you're going to charge for your time. But what if I pay you and we get in there and there's no assets left?
Right.
That would suck.
Yeah, that would.
Here's the priority of how the money in the estate gets distributed. If there's more debts and more creditors than there are assets.
Okay.
Guess who gets paid first?
Well, I would probably say, the government's going to get paid first in most cases. So taxes, I would probably say, is going to go to taxes after taxes. Nope.
I'm getting paid first, the attorney.
Yeah. Well, I guess you are
legal
at
fees.
the top.
Legal fees.
Okay.
Guess who gets paid second after legal fees?
Then I would say the government.
No. Personal representative. You as a personal representative.
Really?
So
okay.
Then the debts of the estate. So again, taxes, the government, they have their own rules, things, but just regular debts, they get paid after. So first the legal fees, second the personal representative.
Okay. And then debt.
Then the creditors.
Okay.
Then the beneficiaries.
Okay. And then so the debt falls under, let's say, medical bills, all those types of things. If they had something associated with medical bills prior to their death, then that falls under the debt piece as well.
Yes. So in debt, I would break it up in secured debt and unsecured.
Okay.
So secured would be like mortgages, where they're attached to the property and things like that. They have that security interest. But medical bills, credit card bills, things like that are unsecured debt. So that's something that a lot of personal representatives don't know about. They don't know that they're entitled to get paid. That's my other reason why I recommend hiring an attorney. So A, you have all the liability, and then B, by hiring an attorney, they can help you get paid, especially if there's multiple beneficiaries. The more beneficiaries there are, the more people you got to answer to, the more likelihood of kind of an issue coming up.
So let's say if someone was named as a personal representative and they don't want to take on that role.
Happens all the time, as you can imagine, right?
Right.
Like they're like, "Ooh, that's me, but I don't want the hot potato. No way, I don't."
Right.
just because someone's named, they don't have to do it. So they can decline to serve, and then it would go to the next person named, if anyone, or if no one else is named, then we're just back to the laws of intestacy. Let's say there was a surviving spouse and kids from a prior relationship. By default, in Arizona, the laws of intestacy, it says that that surviving spouse would receive half of the estate, and also that the surviving spouse has priority to serve as a personal representative. So, but if she didn't want to do it, then the kids could open up the probate, or they could serve as the personal representative. All right, let's see what else. So what controls? We went through that, intestate. Yeah, and then if you're the fiduciary, you just follow the rules. You'll see what they say. Depends on the trust. The trust might have to create additional trust. If there's minor children, or if there's what we call dynasty trusts that are designed to live on. That's part of the job of the trustee to do that. If you're a beneficiary, what I recommend, get a copy of the legal documents so you know what's going on. Ask for an accounting. If they give you a copy of the legal documents, like the will and the trust, and they give you an idea of what the assets are, then be patient. You give them time.
Who could they get those legal documents from? So would the personal representative give them those documents, or is that something that they would get from the court, just depending on what the circumstances
From the personal
are?
representative or from the trustee. When we represent the trustee of a trust, one of the first things we do is we give notice to all the beneficiaries. We do it for a couple of reasons. One, it's the law. Arizona Trust Code requires it. As soon as we give notice, it starts a clock ticking. They have 120 days where they can make a challenge.
Okay.
So we like to do it for that reason as well, too. So if they really do have an issue, it starts the clock ticking. And then really, I just think it's a show of good faith, right? Like, as long as
Absolutely.
if they feel like they're getting the information, we're not trying to hide anything. So I try to be very forthcoming when I'm managing estates, so there's no surprises for the beneficiaries.
Right. Now, is there a certain time frame? Let's say I'm appointed a personal representative. Is there a certain time frame that I have to notify all of those beneficiaries?
Now, if there's a probate, you have to notify them right in the beginning. Well, thanks, Marvin. But let people know where they can find you.
Oh, you can find me at nightowlrealty.com, or you can contact me over at probateinarizona.com. So either one of those two, you can reach me, or you can also reach me out on YouTube. You can find me there. My channel is Night Owl Realty on YouTube, as well as Probate in Arizona on YouTube.
Well, thanks, Marvin. Thanks for everyone watching in the future. We appreciate you. Appreciate your comments. If you have other topics you'd like to hear Marvin and I discuss, leave them below in the comments, and we'll see you next time.
Absolutely. Thank you, Rilus.
Thank you.